Yeah, good morning, everyone. Sorry, Julie, that the meeting was ended abruptly. Professor Oke will join us very soon. He'll join us very soon. Sorry, everyone.
Can you hear me now?
Yes, sir, we can.
Good. I said because of the challenges in the Niger Delta, we've had series of cases of kidnapping of oil officials and the rest. So one of the most innovative provisions of the PIA is what is provided in Chapter 3, which deals extensively with host community development. Before the regime, we had issues in the Niger Delta, the union agitation, and so on and so forth. But because of the challenges in that terrain where Nigeria's crude oil is largely dependent, government initially had to set up Niger Delta Development Commission, which attempted to deal with the issue. Thereafter, before Niger Delta Development Commission, we had OMPADEC, or Mineral Producing Community Development, and so many other initiatives. But under the PIA, we had a different regime, which now tries to deal with those agitations. So you need to trace the history of the Niger Delta agitation. Those are contained in chapter 11 of the book for those who are interested in reading it. So you need to understand that we've had OMPADEC, NEGC, then later we'll have All Mineral Producing Areas Development Commission. Later you have Niger Delta Development Commission. We also have Minister of Niger Delta and so on and so forth. But under the current arrangements, the law provides a structure for oil companies to take care of the host communities, and that's what you have in that position. Is that okay? So under the Petroleum Industry Act, we have Host Communities Development Initiative under the PIA. The PIA sets out clear objectives as for the basis for the new regime, and it provides that the objective for Host Community Initiative is to foster sustainable prosperity within host communities. B, provide direct social and economic benefits from petroleum operations to host communities, to enhance peaceful and harmonious coexistence between licensees or lessees and host communities, as well as to create a framework to support the development of host communities. So they have made provision for what to be done. It is setting up of a board for each exploration that is about to take place. The law requires that licensee or lessee will incorporate host communities development trust. Host communities development trust. The law requires that a settler, meaning a company that is operating in that area, shall incorporate host community development trust, otherwise called a trust, for the benefits of host communities for which the settler is responsible, meaning the oil company will be the one responsible for taking care of the trust. If it is a joint operation, meaning the collectivity of settlers operating under a joint operating agreement with respect to the upstream petroleum operation, they shall appoint one of them to be responsible for it. The Act also provides that for the purpose of the setting up of the trust, in consultation with the host communities, they shall appoint and authorize a board of trustees, which shall be registered at the Corporate Affairs Commission, and they will be in charge of the trust. The law provides for them to be incorporated. Then they will transfer their interest and obligation. PIA provides for the transfer of settlers' interest and obligation to its host community development trust obligation, meaning what obligation they have to develop the host communities will not be ceded off to the incorporated trust on behalf of the community. I will explain the way it happens in real time to you guys so that you guys can. The Act also provides a number of things. The Act listed the objective of the host community development trust, and it's to finance and execute projects for the benefit and sustainable development of host communities. That don't undertake infrastructure development of the host communities within the scope of funds available to the Board of Trustees for that purpose. They are to facilitate economic empowerment opportunities of the host communities. They are to advance and propagate educational development for the benefit of those communities, and so on and so forth. They shall also support healthcare development of host communities. They will support local initiatives within the host communities which seek to enhance protection of the environment. They are to support local initiatives within the host community which seeks to enhance security. They also invest part of the available fund for and on behalf of the host community, as well as assist in any developmental purpose which is deemed beneficial to host communities as may be determined by the Board of Trustees. Of course, the Act provides for sources of funds of the trust, and then it now provides the duties of the trustees, management functions, and the rest. The way they are to allocate funds, who gets what, and how. It also provides to management committee composition and powers in terms of the post community trust fund. So then The needs assessment, development plan, and others is required for each community because they're just not going to be dumping money on them. They're going to come up with a comprehensive list of what it is that they need, as well as development plan for a seamless intervention in those identified areas. So, in a nutshell, what the law provides in terms of host community trust, as I said, because of the agitation in the Niger Delta, militancy, blowing up of pipelines, and the rest, government decided to encourage licensees, those exploring crude oil in the communities, to partner with such communities so that they will have a seamless operation, meaning they will not be kidnapping their expatriate workers, they will not be blowing up their pipelines and the rest. Government initially had series of structures in place. Deck, NEDC, Minister of Niger Delta, and so on and so forth. But the challenges still persist. Now we realize that even the communities are now extensively into bunkering and and others. So to that extent, the law attempted to streamline the intervention of oil companies. Oil companies before the coming on board of the Petroleum Industry Act and the provisions on oil community development through incorporated trust, they will approach those communities and negotiate with their chiefs. They will give the chiefs dollars cash in most cases, and the money given to the community leaders or the militant boys often form basis of agitation because people always fight over such funds and always created tension, crisis. If they give money to the partner A of the militant group, Group B will go out and chase the oil companies. Oil companies will be wondering, we've settled you guys now. Why is all these things happening? So the government felt they needed to create a proper structure. So once an oil company is allocated an oil block, for instance, oil block is given to you in the community in Bayelsa, let's say Akoka. So if an oil company is giving an oil block in Akoka, instead of giving money to the chiefs and area boys and what have you, the law says the money they want to give to them should be channeled through a trust fund that is incorporated under Corporate and Allied Matters Act, like a company. It will set up its own board, to set up its own management committees and what have you, so that the money is given to that trust. The trust will now administer it. If it's to buy books, it's to build hospitals, it's to buy cars, it's to fund community fishing festival, if it's to give scholarship to them, if it's to build hospitals, clinics, or even give them cash for whatever reasons, under whatever guise, it is now the duty of the trust fund now, which is a legal entity, to identify the needs of such communities and channel the resources to them. And then the trust will identify the respective groups and interest groups within the localities and try to structure them so that it becomes something that is holistic. And that will now reduce the tension and restiveness in the Niger Delta. That's the structure in a nutshell. So instead of giving money to the boys that are there, give to this, to now have a formal structure in place to deal with the agitation of the host communities. Is that okay? Is that okay, guys? Hope you guys got the gist.
Yes, sir.
Yes, sir. Yes, sir.
Good. That's the way it works in practice. And that's that's the totality of the grammar that you have in the law, providing for this, providing for that. That in essence is what the law is saying, and that's contained in chapter 11. I'm sure you have read it ahead of time. So let me also briefly go to local content before I wrap it up with technology transfer. Local content is provided for in chapter 22 of the book. Local content generally is now incorporated by reference in the Petroleum Industry Act of 2021. So because federal government exercises ownership of the natural resources. So the Nigerian government says for us to show ownership of these resources, we must take charge. To that extent, Nigerian government realizing that multinationals still dominate the oil industry and that they are the one calling the shots in terms of who to employ, how to pay the employees, transfer, and what have you. Government decided to come up with a policy that regulates the number of expatriates that can work in the oil and gas industry, including when such will not be possible if there are local experts in the industry. For instance, if they want to employ an engineer who deals in hydrocarbon, the law would not allow them to bring in an expatriate for as long as there's a local expert who can handle such. So it's to enable Nigerians to benefit from their natural resources. That is the essence of the local content law. So to that extent, Nigeria enacted a law called the Nigerian Oil and Gas bracket open Industry and Content Development bracket close Act of 2010, otherwise called the Local Content Act. The act is strategic for various reasons, particularly given the historiography of oil and gas governance in Nigeria. Because the law tries now to change the dynamics. So it provides essentially that certain things should be reserved for Nigerians. So Section 15 of the law described the law applies to Nigerian companies, and all those multinationals must first register in Nigeria as a Nigerian company so that they can come under the applicable provisions of the law. Section 15 describes a Nigerian company as a company formed and registered under the Companies and Allied Matters Act, with not less than 51% equity by Nigerians. So the law shows beyond doubt that multinationals must have at least 51% ownership given to Nigeria. And that's what is being replicated right from the era of Nigerianization and unfortunately when we have a Nigerian National Oil Company, NNOC, later NNPC, now NNPC here, and the local content division under the old NNPC. Local concept is conceptualized as a protectionist policy, which aimed at shielding the Nigerian economy, meaning protecting the Nigerian market from being exposed to foreign domination. I don't want to go into the theories of distinguishing local content from protectionism, but that's not why we're here. It's important to know that the local content provides for a number of things, and I will give you just a number of what the law provides. So Section 1 provides for the application of the Act. It says that notwithstanding anything to the contrary contained in the Petroleum Act or any enactment or law, including the Petroleum Industry Act now, the provision of the Act shall apply to all matters pertaining to Nigerian content in respect of all operations and transactions carried out in or connected with the Nigerian oil and gas industry. So in this with transactions, everything and activities in the Nigerian oil and gas industry. Section 2 is an appeal to all regulatory authorities, operators, subcontractors, alliance partners, and others involved in project operation and activity or transaction in the Nigerian oil and gas industry to consider Nigerian content as an important element of their overall development and management philosophy when they are executing. So Section 3 stipulates the indigenous companies and independent operator in Nigeria shall be accorded first consideration in the award of oil blocks. Section 3.1 states that Nigerian companies and independent operators that are Nigerians shall be accorded first consideration in the award of oil blocks, oil field licenses, oil lifting, and all other projects being awarded in the Nigerian oil and gas industry. And Section 3.2 reinforces compliance with it. Section 4 provides for the Nigerian Content Monitoring Board. Section 6 provides for modification of all existing petroleum arrangements and so on and so forth. Section 8 empowers the issue of certificate of authorization when an operator plans to plan as when an operator plan has reviewed and assessed is in conformity with the process of the Act. Certificate of authorization is what they give to them when they want to take certain steps for them to confirm that what they want to do is in line with the local content provision. Meaning, for instance, they want to bring in some expatriates and they will have to make justifiable reasons why they need to bring in those expatriates, showing that there are no Nigerians qualified to take on the jobs or something like that. So that's what the law is saying. So it requires them to submit report, to submit reports on employment and training plan, E and T, in case there are no Nigerians in there. An interesting aspect of local content act is section 31.1, which states the requirement for succession plan and administration position. It states that for each of its operations, the operator shall submit to the board a succession plan for any position not held by Nigerians. Such succession plan shall provide for Nigerians to understudy each incumbent expatriate for a maximum period of 4 years. At the end of the 4-year period, the position shall become Nigerianized. Note that particular provision. Once they're given the certificate of authorization, meaning they can bring in expatriate because there are no Nigerians in there, then they will need to now show a succession plan under employment and training plan. That, okay, this position that is being filled by a non-Nigerian, the Nigerian must understudy the Igbo so that for the next 4 years, he'll be able to do what the Igbo is doing. After which the Igbo will go, or the Nigerian will stay, or both of them may stay. It's just to kind of bring back the Nigerian content to ensure that the benefit of the industry is not taken away from them. There's so many other provisions on the local content that you need to pay your particular attention to. And then there is the same thing also applies to legal services. Section 51 of the Act says all operators, pay particular attention to that one too. All operators, contractors, and other entities engaged in any operation, business, or transaction in the Nigerian oil and gas industry requiring legal services shall retain only the services of a Nigerian legal practitioner or a firm or firms of Nigerian legal practitioners whose office is located in any part of Nigeria. All operators shall submit to the board every 6 months its legal services plan. Section 51(3) also states a comprehensive report on legal services utilized in the past 6 months by expenditure and forecast of the legal services required during the next 6 period and projected expenditure. It shall also show a list of external solicitors utilized for legal services in the last 6 months and the nature of work done and the expenditure made by the operator. It will also show the annual legal services budget for the past 1 year in Naira and foreign agencies and foreign currencies. So the Act tries to instill local content, even in the oil and gas sector, for purposes of legal services. I guess that will interest you guys. So a similar requirement is provided in section 52 for financial institutions, which means they will also retain services of Nigerian chartered accountants and what have you. There's a provision for Nigerian Content Monitoring Board, which monitors compliance with what the law has stipulated, and they impose sanctions. The board is constituted under the Act, and their job is to monitor things in that industry. There's also the Nigerian Content Development Fund, established under Section 104 of the Act, which is a pool of funds that oil companies contribute into. It says under Section 105 of the Act, the board, the Content Board, in conjunction with the MASA, is also empowered to enforce compliance with relevant sections of the Coastal and Inland Shipping Cabotage Act number 5 for 2003, which is also a similar law, local content for shipping matters in Nigeria. Then there are so many other issues that you can look at. So you need to also know how to compare local content in Nigeria with local content in other jurisdictions. I have a number of such provided for you guys. So go and read up on chapter 11 to have a better understanding of it and form your own. That's that on local content. The last issue I want to engage you with briefly before I let you guys go
Hello, sir. We can't hear you, sir.
Hope you guys can hear me now.
Yes, sir, we can.
The network has been fluctuating. Let's quickly wrap up, please. Technology transfer is an attempt also to, it's not limited to the oil and gas in any industry, but it's an attempt to ensure that Nigerian petroleum sector develops like their sister sectors in other countries. So it's an attempt to ensure that the skills, technology needed in the sector is retained in Nigeria so that Nigeria will continue to maximize the benefit of the oil industry. Technology transfer is not a new development, it's been around for a while. And just that it's not being made an essential part of the Nigerian law. And I'll read out instances of that for you now, briefly, in kind of an outline form. The concept of technology transfer known as TOT is not a new phenomenon as it has been in existence for several decades. The issue of transfer of technology to developing countries has been a frequent subject of discussion and a subject of discussions at the international levels, particularly at international economic levels. Then initially we had the World Intellectual Property Organization, WIPO, which defines technology as the systematic knowledge for product manufacturing and service provision in industry, farming, and commercial fields. That's the definition of WIPO for that. The International Code of Technology Transfer defines it as systematic knowledge for the manufacture of a product, the application of a process, or the rendering of a service, whether that knowledge be reflected in an invention, an industrial design, a utility model, or a new plant variety, or in technical information or skill, or in the services and assistance provided by experts for the design, installation, operation, or maintenance of an industrial plant, or for the management of an industrial or commercial enterprise. We have so many definitions. Petroleum technology, more specifically, has been defined as a body of knowledge formulated about the industrial activities in the field of petroleum and capable of changing as a result of research activities leading to new discoveries. It has two aspects. We have the tangible and the intangible aspects. The tangible refers to the physical embodiment of the technology, that is, the equipment, tools, machinery, and plants. The intangible, on the other hand, relates more to the knowledge and skill and the ability to use this knowledge and skills to repair, maintain, and create modifications and innovations of the physical asset which is imported. The essence is to ensure that the gap is filled, that we don't continue to import those skills and technologies, and that local actors can produce or command those positions as against bringing foreigners to man those better positions. That is That in a nutshell is the essence of technology transfer. Then we have several definitions of technology transfer, which I shouldn't bore you guys with. But technology transfer in the petroleum context refers to a process which enhances the ability of developing countries concerned to monitor and control the petroleum sector activities, to acquire directly the most appropriate means for exploration and development, and strengthen the domestic capability to utilize these means effectively by itself, if necessary, without outside assistance. Meaning a situation in which Nigerians are able to take charge of the petroleum industry without the use or the need for expatriate. There's so many other definitions of that, then you guys can read up on that. Evolution of technology transfer in the petroleum sector. During the colonial era, technology transfer by colonial masters to production entities in their colonies was mainly in the private sector, mining, plantation, and agriculture. Technology transfer of the era was aimed at the development of methods and techniques in order to obtain maximum input. In this era, transfer of technology by multinational companies became common, and public international bodies and non-profit organizations also got involved in such activities to transfer knowledge. So, but with the coming on board of multinationals, they came with the technologies, and the major technology transfer concern of the period were expressed by way of terms of technology transfer, distribution of technology rents, and loss in dynamic technology capacities. All those happened when they started getting involved in exports and multinational activities. So then they started advocating all these technologies that we brought, we need to give it back to us. You are the one manning the installations. You are the one manning the oil blocks. You are the one manning the pipelines. Now, if anything happens to those pipelines, they will have to bring in expatriates at huge cost. And nothing is retained in Nigeria by way of benefit. Then the arguments continue. Then the accusation became sustained, and the multinationals started entering into definite agreement with the local actors as to transfer of technology. So they now signed specific technology transfer contracts which sought to address issues of pricing monopoly, restricted business practices, and export restriction. All those were dominated by foreigners. They determine the price of those technologies, determine the kind of business they want to get involved in, determine what they export because they're the ones in charge, determine where they want to extract crude oil from. That's why they can even go to the communities and scratch the surface and explore for oil, as against going to deep waters and the rest. So all these agitations continue until we had legal framework to challenge the way certain things are being done. So Nigeria has had its own experience in terms of technology transfer as a nation, and those are listed in the book. So we had in 1973, on 4th of June 1973, the Petroleum Technology Development Fund was established as a fund for the purpose of training and education of Nigerians in the petroleum industry. This was in a bid to motivating technological learning and local absorptive capacity for both upstream and downstream petroleum operation through research and training. Prior to the establishment of Petroleum Trust Development Fund, there was in existence the Gulf Oil Company Training Fund, which was subsumed later under PTDF. In 1975, the Petroleum Training Institute was established towards the development of technological capabilities in the oil industry. The purpose of its establishment was to provide course instruction, training, and research in petroleum technology, and to produce technicians and skilled personnel required for oil operation. And we had a series of other developments in that regard. So we now had listed provisions for technology transfer, statutory provisions on technology transfer. We have in the old Petroleum Act repealed. We now have similar provisions under the Petroleum Industry Act. So we have them under the Nigerian Oil and Gas Content Development Act. You need to be able to identify statutory provisions that contain transfer of technology. We have in the Petroleum Industry Act, as I've indicated, where it charges the authority and the commission with specific duties in that regard. We have institutions for technology transfer in the energy sector. We have the National Office for Technology Acquisition and Promotion, NOTAP. NOTAP is also one of the subjects you have to study under this course outline. NOTAP is National Office for Technology Transfer. It deals with all kinds of technologies and requires the registration of inventions. So read up on NOTAP. One of the mandates of NOTAP as an agency is to encourage efficiency in the process of identification and selection of foreign technology. It includes the development of negotiating skills of Nigeria with the view to ensuring best contractual terms and conditions for Nigerian parties sharing in contract or agreement for the transfer of technology to ensure a more efficient process for adaptation of imported technology. NOTAP has issued several publications, and you need to read up on NOTAP as provided in the chapter. Then the Nigerian Content Board, which is a body under the Local Content Act, also is an institution charged specifically with local content issues. We have the Department of Technology Acquisition and Assessment, TAA, in the Ministry of Science and Technology. It also functions as an institution charged specifically with functions relating to technology transfer. We have the National Center for Technology Management, NACTM, which also is another parastatal in the Ministry of Science and Technology. We have several that we have FIRO, Federal Institute of Industrial Research. It's also an institution. We have transfer technology through oil contracts. When they enter into specific contract for purposes of oil exploration or related activities, the contract may provide specific clauses for transfer of technology. That's also one of the means of transferring technology. We also have clauses in the employment or training of nationals when they engage them. It's also a means of transferring technology that says, oh, once you employ, you go for training, monthly training, and what have you. We also have similar provisions in Type 2 of equipment. when they transfer technologies, when they rent equipment, there's also a clause in there. There's so many provisions on technology transfer that you can study. And chapter 25 is just a guide. You have it in other areas where you can further broaden your knowledge on technological transfer of technology. That said, I leave you guys there. I've covered my home components. What you expect from me is 5 tutorial questions, which I will give to you just about the time. When are you starting your exam?
Hello, sir. Yes.
Yeah.
Yes, sir. We
When
are
are you
starting
starting?
our exams on the 17th, sir, next month. But sir, there's a 17th
Wait.
next month, sir.
17th of March.
March, yes, sir.
Yes. Mm-hmm.
But sir, there's a concern, sir, amongst the class.
Yes. Yes.
Yes, sir. The timetable that was released, we saw that we have 2 papers on the same day, sir. We have petroleum law and principles of equity, and we've tried to see if we can get one moved to another date for the sake of comfort, sir.
Yes. You want me to be the one to deal with that?
No, sir, but we just wanted to bring it to your notice too, sir.
There's nothing I can do. I'm not the one in charge. I don't want to lower myself to have to be advocating for student timetable. I'm not even supposed to. Those are basic administrative things for our very junior colleagues. All you need to do is just to complain through the subdean and your student body. Go through your body to complain.
Okay, sir.
Yes, that's why you have a union. You play the right to do whatever CDD, and the time to start is now. So that take the remaining time to read up on more what you've been taught is wide, and you have a lot of materials to read. It's not going to be a walk-away exam like that. It's going to be comprehensive. You just dip yourself in the knowledge and do whatever you have to do. And if you need to talk to me on some things, you can always talk to me from now, whether or not I'm in the country. So that said, I wish you guys a nice day. Bye-bye.
Thank you very much, sir.
Thank you very much, sir.
Bye, guys.
Thank you, sir.